Welcome back, everybody, to our studies in criminal law. Over the last few lessons, we have been spending a lot of time talking about the law as it relates to sexual offences law. Now, we've been unpacking each and every different piece of content that relates to this area, focusing quite a lot on the idea of consent being the key element especially when it comes to sexual offences as codified in sections 1 to 4 of the Sexual Offences Act. We talked about the issue of deception as to the nature of an act, which could then be construed as a denial of consent, as well as talking about belief in consent and the reasonable belief in consent, which is also a requirement to show as part of the mens rea of the offences under the Sexual Offences Act. This lesson isn't going to deal with consent, but it's going to deal with the victim of sexual offences, i.e. specifically the case study of the various different provisions which are established in the 2003 Act which concern children. We're not going to spend too much time looking at various different pieces of case law because fundamentally the key questions and the key issues, and more importantly, the key difference between adults and children in terms of sexual offences, as victims at least, concerns issues relating to consent, belief in consent, as well as being essentially codified in the legislation itself. So it's important that we just deal with the legislation. So, this is the final lesson on the subject of sexual offences. After this, we're going to move on to looking at non-fatal offences, so things like assault and battery and GBH. And just like I said, we're going to spend a little bit of time examining the commission of sexual offences against children and how the law deals with this issue. Now, theoretically, we could have carried on and talked about sexual offences in various other contexts as well, in conjunction with what the legislation does. So, for example, sexual offences as committed in a family relationship, for example, or sexual offences against animals and all these different kinds of things. But we're not going to do that. We're just going to deal with children, and we're going to then move on to looking at non-fatal offences. So, the regulation of sexual offences as they relate to children is seen in sections 5 to 9 of the Sexual Offences Act. And the provisions of sections 5 to 9 loosely mirrors that of the provisions that we see in sections 1 to 4. The only difference, of course, being that sections 1 to 4 deals with adults for the most part, or at least has adults in mind in consideration of sexual offences, and sections 5 to 9 deal with children of certain ages. And really, the distinction you are going to have to think about when we think about sexual offences against children, and if you have a problem question that is relating to this issue, the first thing you're going to have to ascertain is the age of the child, because depending on the age of the child will depend on the how the law treats the alleged allegation of a sexual offence. So firstly, it should be noted that not all children in a strictly legal sense are unable to consent to sexual activity, because the age of consent is actually the age of 16. And of course, the age of majority goes all the way up to 18. So if you're 16, 17, 18, or 16 and 17, should I say, then you are still a child, but you can consent. So we have to make it clear that there are instances of where people who are legally children, because the legal age up to which you are a child is 18, legally you are a child, but you can still consent because the age of consent is 16. But given that, and going below the age of 16, the nature of liability will heavily be dependent on the age of the child. And there are two delineations that are made here. There are 2 points of age which is of our concern. So you have got to think about sexual offences that are committed against children under the age of 13. Okay, so quite significantly under the age of consent. And then you've got the people who are over 13 but under the age of consent. So between 13 and 16. This is another area. And these areas are both treated differently in the law. So Between 13 and 16, there is a certain way in which the law treats cases involving sexual offences, and then between 13 and below, all the way down to as young as you want to go, we'll deal with how the law treats these people as well. We'll begin with the first, with the youngest, sexual offences committed against children under 13. Now, the most important thing to remember is that where sexual offences are committed against children under the age of 13, it does not matter if you have ascertained consent, because there's no such thing as consent of somebody who is under 13. Even if the person who is under 13 says that they have consented or says that they are willing to engage in sexual activity themselves, that they cannot consent. But secondly, that you have no knowledge of the age of the victim. Assuming, let's say, for example, you believe the victim to be over the age of 13. This is completely irrelevant to the consideration of sexual offences and your liability in law under Sexual Offences Act, under sections 5 to 9. The reason why is because sexual offences that are committed against children under 13 are strict liability offences. So we can see here that section 5 says the following. It says, the definition being the rape of a child under 13, and they say that a person commits an offence if he intentionally penetrates the vagina, anus, or mouth of another person with his penis, and the other person is under 13. A person guilty of this offence is liable on conviction of indictment to imprisonment of life. That's just the sentencing procedure, the sentencing guidelines that are presented by the legislation. So section 1 is what's important in defining the offence. Notice there is no mens rea. There's no mens rea. There is an actus reus, the intentional penetration of the vagina, anus, or mouth of the other person, and then there's just another element of actus reus, which is that the other person is under 13. You don't have to have any reasonable belief in consent. There is no reasonable belief in age. If you do these two things, then regardless of whether or not the person under the age of 13 said that they were 17 and said that they wanted to have sex, these things do not matter. A person is still liable in law as a result of these actions. The only mens rea element that is of relevance, I guess you could argue, is the intention on the part of the defendant. So the intentionally penetrating the vagina, anus, or mouth of the person with your penis, that is considered to be the mens rea element. So if you have done that thing, then, and you have done so intentionally, of course, then you have therefore committed an offence under Section 5. The offence is, like I said, strict liability as it relates to both the age of the victim as well as consent. There's no such thing as consent under the age of 16, even if there is this sort of alleged understanding of consent where the 13-year-old or the person who is under 13 believes that they want to have sex. They cannot consent. They have no ability to do so. Consent is not a defence. Lack of knowledge as to age is also not an offence. What about then sexual offences for children who are over 13? So this sort of like 13 to 16 group, so 14 and 15 for the most part. Well, there's slightly less strict in terms of how we treat strict liability in this case, because the main difference here isn't that there is a knowledge of consent or a lack of consent or whatever. Again, anybody who is under the age of 16 cannot consent to a sexual activity because 16 is the age of consent. But the thing that is added to this consideration is knowledge of age. Okay, the law recognizes that people between 13 and 16 may, in some cases, look older. And so theoretically, the defendant can have a defense on this if they reasonably believe that the person is over the age of 16. This is the additional mens rea pertaining to a lack of reasonable belief in the victim being 16 or over. This does not apply to people under 13 because knowledge of age is irrelevant to that consideration. It is only between 13 and 16 that we see that this consideration is added into the legislation. This is in Section 9 of the Sexual Offences Act, and this is just to illustrate the point. This is sexual activity with a child. They say here that a person aged 18 or over, A, commits an offence if, we'll get to the age element here in a second, commits an offence if he intentionally touches another person, B, the touching is sexual, and either B is under 16 and A does not reasonably believe that B is 16 or over, or B is under 13. Note here that this covers both sections. It covers both the sort of 13 to 16, but it also covers people who are under 13. And notice here that this really nicely shows the delineation between the strict liability of under 13 sexual activity versus the strict liability of between 13 and 16 sexual activity. The between 13 and 16 sexual activity has this additional caveat that A does not reasonably believe that B is 16 or over. And then we don't have this caveat if B is under 13. This is the consideration for people who are between 13 and 16 when it comes to sexual offences.